Hello, everybody. Hi. Oh, golly, I forgot the fans were there. Do I look like I've been balling for 2 days? Because kind of have been. Oh boy, those carpets took everything out of me and then some. Thankfully, I've got, the PAWFURM here helping me. They were there for emotional support, not much else, but emotional support and treats. They're there for the treats. But I got them done. Thursday I was up until, well, into Friday, up until 7 a.m. And then, oh, no. Friday into Saturday. Yeah, Friday into Saturday, I was up until 7 a.m. And then Saturday night into today, I was up until 5:30 a.m. And yeah, it took a lot. Where'd the other one go? Did I give you all three already? Okay. I know Bandit didn't eat it. So you must have had all three. And I'm still snuffly too. Go figure. But I'm blessed to be here. And I am so grateful to be back. Hello, K-John Boom. Well, you're first tonight. Hello, Nana Laura. Hello, Amanda Roderick. Oh, well, I hope you can at least be here for like the first one, because that's the South City at Moorish National that I found. Oh, that's so sweet. I hope you guys enjoyed your time together. That's a really special thing. And you're very blessed, both of you. Hello, C-Rex, honey. Hello, Linda Applegate, sweetie. Hello, Mortimer Duke. I can't wait for your puns tonight. Hello, Eileen Carlin. It's always almost immediately. Always. Bandit's licking her plate right now. Ava's got her 3. It was less than 2 minutes in. Hey, see, half a minute. Yeah. It doesn't take long. They've got me trained. Hello, Charlie. I love you. Hello, Jerry Matthew Boyd. Welcome back. Hello, Army Brat 1964. I've missed you. Hello, Spider-Man honey. Thank you for always being here. Hello, Mark Addy. Good to see you, sweetie. I've been trying, but work's gotta be done, and this is my job, as well as, like, my sanity. This is where I find my happy place, right here with all of you. Hello, Sandy Hurd, sweetie. I think I think Sandy Hurd is the one that mentioned that there is a little trick that subscribers can do to help out content creators, and that is after the video, just go into the comments and leave an emoji. Anyone, it doesn't matter. The algorithm looks at the number of comments, not the content of the comments. So you don't have to leave any long, big replies or, analogy of the video, unless you really want to. I mean, I love reading them. But anything at all, anything at all, if you go in and just leave a comment, that helps out super big. I'm unfoiling my Dayquil. So yeah, if that's something that you guys have in your heart to do for me, I would greatly appreciate it. Oh, I'm so happy. I'm glad you like it, sweetie. Yes, of course. She usually gets different kinds of treats. Usually it's like, half my dinner or something like that. I shared banana bread with her last night. Oh, hopefully that helps with my snuffles. And this cough that just won't quit. Darn allergies. That's it. I'm still saying it's allergies, guys. Hello, Jenny Green Honey. Not right now, you don't. Maybe in 2 hours or so. I love you, Bandit. Ha! I made 3 3 days ago, something like that. I was gonna give one to the Quick Trip cashier lady because when I went there to buy overripe bananas, they were all out, and I asked her if they had any like in the back. I know, Karen move, right? No, I figured maybe they'd been wasted out and that they were, waiting to go out to the dumpster, but they had already gone to the dumpster. And she was so funny. She goes, the only thing that I can suggest is like go out there and like, kind of dig around. And I'm like, in the dumpster? She goes, oh no, on the shelf. I'm like, I already did that. I'm like, I thought you were telling me to go dumpster diving. I'm not above it, but you might get in trouble for giving me permission. But yeah, so she when I told her that I wanted the bananas because I wanted to make banana bread tonight, she's like, and then bring me some. I'm like, I don't know, chocolate chips or no chocolate chips. Yeah. So I had every intention of taking it to her, but it came out really dry because I couldn't find enough bananas. I bought like not quite ready bananas, for not quite ready for banana bread bananas. And there's a trick where you can microwave them or bake them in the oven with the skins on. So I tried that trick. It doesn't work as well as having actually overripe bananas. So, yeah. I have no shame. Are you kidding me? With the life I live, I have no shame. My morals are kind of sketchy too. Okay. my newly medicated cat. They put her on gabapentin, and it's one of these types, and it's a half of a dose. So I have to open this up, like measure out half of it, dump it onto the plate, and then put it back together and give her the other half. It's every 12 hours. So she just had her dose because I'm doing it at 11. That way it's, I'm up, and it's right before the stream. So she's tolerating it well, but you can definitely tell that she's medicated because she's not used to it yet, and she's wobbly in the legs, and yeah, I don't like that. But it has not seemed to help her slow her roll with her hatred of Earl. He comes anywhere near her and she hisses. Oh, she hisses. So, yeah. Hey, Donald Westerdale. Good to see you, honey. Hello, Manuel. Who's Gabby? Good old Gabby. Oh, gabapentin. Took me longer than it should have to figure that out. I was looking for a subscriber named Gabby. I was wondering what friend I missed. Yeah. It is. Well, it's $21 for the month at her current dosage. I mean, I'm on gabapentin, but mine are 600. So, like, I seriously considered, cutting mine up and hoping I got it right, but no, I'm not going to do that. I'm glad I gave you a smile. Yeah, I get it now. I'm slow, y'all. You want to make me laugh tomorrow? Tell me a joke today. Hello, she's a maker. I missed you too. Oh my goodness. 3 days off is not my ideal. No, no, no. Oh, you are so blessed. Hey, hey. There are treats on that plate, and you're still over here pawing at stuff. What are you trying to get? I just don't know. I just don't know with you. Oh, for your cat? We're talking about cat medicine, cat gabapentin. It's my kitty baby. It's my bandit. Mwah. Mwah. She's perfect. She's the reason I have to steam clean the carpets, but she's perfect. Yeah, I know there is. Oh, every time I go to click something, someone says something and it moves it, which is fine. I'm okay with that, obviously. I want you guys to comment. I'm just letting you all know on replay crew, if weird comments pop up at random that don't make any sense as to, context, that's because the chat jumped. I'm lucky that I have such a small crew to work with, otherwise I couldn't keep up or pick a comment, and goes too quickly. I don't know how those big streamers do it. Excuse me. Sorry about that, guys. All right, let's watch a Sav sit be dumb and arrogant and well, usual, the usual.
All right, we're good.
Yeah, if we can go to the Iona Jail, Your Honor, and call the case of People v. Milton Hensley, case number 23S18766FH. Defendant is present via Zoom from our jail. He is in co-per, I believe so.
All right, Mr. Hensley, how are you today?
Objection. Malik B.
All right. So, Mr. Hensley, we've been through this before. I'm going to call you by the name that's found on the information here.
You have my nationality information. You have my.
So, Mr. Hensley, are you representing yourself today?
Proper persona sui juris.
All right. Are you representing yourself today, sir?
Propria persona sui juris.
All right, so Mr. Hensley, I'm not certain what you mean by that phrase. All I'd like to know is that whether you're representing yourself today or not. We've had this conversation many times previously. It's up to you, sir. All right, so Mr. Hensley, you don't have a response for the court?
Well, you don't know what proper persona sui juris is? That means somebody presenting themselves.
All right. So is that what you want to do? Is represent yourself today?
I'm presenting myself, Islam. Yes.
Okay. And then, as we've talked about several times, do you understand that representing yourself can put you at a disadvantage to other folks, like the people who have attorneys that are representing them? Do you understand that?
No, I do not.
Okay. What don't you understand about that?
None of it.
You don't understand any of it?
I don't understand how the disadvantage.
You don't understand what?
Did you say the disadvantage?
Yes.
How's the disadvantage? In what term? In what manner?
So the disadvantage would be that they're familiar with the rules of court, that they're trained lawyers and the rules of evidence and things of that nature, things that we've discussed many, many times.
So are we talking about law, or are we talking about codes?
We're talking about statutes. We're talking about court rules. We're talking about case authority. Do you understand that you could be at a disadvantage?
I understand law. Are we discussing law or
I'm not going to play this game. Hey, Deputy, I want you brought over here in person. We'll put this all on the record. We're going to put this on the record in person. We're going to get Mr. Hensley sentenced today, and we'll make a complete record, as complete as we can. But I want to do that in person because we can do this all morning via Zoom, and it's just not very conducive to that. So if he can be brought over, and then we'll continue with our doctor until we see him here. What do we have next that we can do?
Case number 23S18766FH, People v. Milton Hensley Bay Jr. Defendant is present. He is in person. He is in co-per. Today's the temperature for sentencing. And in front of him at the podium, I've provided 2 copies of his right to appellate.
All right. So, Mr. Hensley, we are back this morning for Sugar Court sentencing. He's appearing in person. We did try to start this earlier with him remote at the jail. It just made more sense for the court to have him present, where we're not trying to talk through Zoom. So, Mr. Hensley, here we are again today, sir. First, I want to start with this. When I arraigned you a couple weeks ago, you were given the opportunity to request court-appointed counsel, and you were also given the opportunity for the last several months to retain your own counsel. Are you representing yourself today, sir?
For objection, for the record, let the record reflect. My appellation is Malik, title is B. Works American National, I'm the Islam.
Anything else?
Proper persona, sui juris.
All right. So, sir, the information that I have in front of me has your listed name as Milton Joseph Hensley Jr. So we've been through this before. Respectfully, I'm going to call you by the name that is listed in the information, Mr. Hensley. So, Mr. Hensley, do you wish to proceed by representing yourself today, sir?
Open my Fifth Amendment right.
All right. You don't wish to answer any questions from the court?
Open my Fifth Amendment right.
All right. So you're not going to answer the court when I'm asking, do you wish to proceed representing yourself today for circuit court sentencing? You wish to do that, Mr. Hensley?
Objection. My appellation is Malik, the title is B.
All right. So then let's get this on the record. As far as the PSI, Ms. Bond, it would appear that the court has a copy of this. Mr. Butler apparently has it. And then what do you know about Mr. Hensley receiving this copy?
That he was emailed a copy, and it's my understanding one was picked up at the office by someone important.
All right. So, Mr. Hensley, have you had a chance to review the pre-sentence report, sir?
Objection. My appellation is Malik, title is B. And for the record, you have my nationality information within your files. So you know my appellation.
All right. So, when was our PSI completed, Ms. Bond? Looks like 2/29 of 04.
Yes.
Had it, reviewed it. And so after the review, that would have went out to all the parties or sometime in March. Okay.
Just while I'm pulling this up, it appears that there would have to be an addition in jail credits.
Okay.
As he was arrested on the bench warrant, there's an additional 12 days from 4/18 of 24 to today.
So we can make that correction and update the jail credit.
The PSIs were sent out on 2/29 today.
So I also want the record to reflect, I've seen Mr. Hensley several times as it relates to sentencing. He had been appearing for all of his court appearances. He had been cooperating with the court as it relates to expressing his desire to represent himself in these proceedings. He's never wavered from that, which is why the court is inquiring again today. I recognize that sentencing is an important part of the circuit court process. It's certainly a hearing, if you will, that would require and entitle, I should say, the defendant to the assistance of an attorney, which is why I'm asking. However, the court is balancing that with the idea that this circuit court sentencing date has been delayed several times, and the court can't help but glean at this point it just appears to be a delay tactic. The court, we sift that back through the dates, has given Mr. Hensley several times to hire counsel. He expressed that interest. Again, it appears in hindsight that it's simply a delay tactic. Court has given Mr. Hensley several times, actually not even with the sentence that the court's required to give here in a moment, keeping him out on bond to do those things, explore counsel. Even after being arrested on the warrant when he failed to appear, court also gave him the opportunity again to request court-appointed counsel. In fact, the public defender's office appeared at his arraignment. Mr. Hensley Bay has had the ability to fill out the affidavit and request counsel. Here this morning, in response to the court's questioning, he does not appear interested in answering the court's questioning. Again, it appears to be a delay tactic. I am comfortable that the pre-sentence report has been provided months ago to Mr. Hensley. I am comfortable Mr. Hensley has been given ample opportunity either to retain counsel, to ask a court-appointed counsel. And therefore, the court's going to proceed with sentencing today. I can't continue to allow this delay of the matter in what appears to simply be at this point, series of incidents and responses, or lack thereof of responses, simply to delay the matter. I know Mr. Hensley's been engaged with this. We have several filings that are not court filings that he has continued to send to the clerk's office, some of which he has referenced, none of which have anything to do with the case and or the court's requirement to get him sentenced now that he has been convicted several months ago of these crimes. So what I'm going to do is I'm going to start with then Mr. PAWTNER. As it relates to the PSI, are you aware of any corrections, additions, or deletions that need to be made with it other than what we've already placed on the record with probation?
I would just ask the court to take a look at offense variable 4 regarding psychological injury to the victim. We did receive a victim impact statement. It looks like it came from Robert Siegel, who was the male occupant of the vehicle. In this case, the victim. We received that just this morning, about 2 hours ago. By email. So I could read that. I do believe it references facts to validate scoring for week 4.
All right. So why don't you read that?
Okay. This is from Rob Siegel. That's S-I-E-G-E-L. He says, I do have things to say to the judge and the proceedings that I would like to be read during the sentencing below. Your Honor, I apologize for not being here in person today, but I could not find the time again to keep seeing this through. The amount of stress and anxiety Mr. Hensley has caused my family is downright disgusting and infuriating. Pull a gun on a family driving down the highway for nothing more than getting out of his way not getting out of his way fast enough is obscene. My daughter, who was only 9 years old at the time with special needs, was terrified, and it took months for her to feel comfortable riding in any vehicle again because she was scared someone was going to cut her life short for seemingly no reason at all. My wife had to start and is still in therapy over this whole situation, which has thankfully helped her anxiety levels to become manageable, but also is not covered under our insurance. So it's cost us quite a large sum of money, and that brings with it its own stresses to our family and social life. I find myself driving and cannot seem to relax because anyone I see speeding up behind us reminds me of the terrible people in the world and just how ignorant someone can be with disregard for others' lives, including those of its own family and child in the car. Being that there are previous charges against Mr. Hensley for almost the exact same situation where he brandishes a gun and threatens to kill people because of his unchecked aggression and inability to safely operate a vehicle, which then turns to road rage, I plead that the court recognize this man is a danger to society whose blatant disregard for human life will eventually cause someone to lose theirs, if not his own. Because of all the pain, sufferings, financial burdens, and overall creation of trauma and issues in the many lives he's affected, I petition that the court give Mr. Hensley the maximum sentence possible for his crimes, so that my family and others he's affected may know some semblance of peace. To Mr. Hensley, despite everything you've done to my family over this very long process and the disdain I have for you as a human being, I hope that your time behind bars will allow you to see life differently, and that you can truly find the error of your ways to become better for yourself and your family. So with that statement, I think we have 2 individuals that are reported by Mr. Stagel to have suffered emotionally from this. His 9-year-old daughter and his wife, both of them were in the car at the time. I think that would validate more than 10 points.
I object to that.
Hold on, so, Mr. Hensley, what is your objection?
Tell him prove everything he's saying. If his wife and everybody went through the trauma, show me the doctor did and report that he went through it. Because I can't believe somebody that was slamming the brakes on the interstate at 75, 80 miles per hour deal with trauma. You could have killed us and everything behind me.
Oh, blame the victim. Swell tactic. Let's see how it works out for him.
Ain't no such thing as you got trauma for you slamming your brakes.
All right,
Prove the accusation that he's making. Prove it.
all right, so sir, I am
Instead
gonna
of reading the
grant,
script like you coming from a movie or something.
I am gonna grant the request for scoring OB4 based on the victim impact statement here. It does appear to meet the definition. Now, OB4, for the record, psychological injury to a victim could be scored 10 points if the serious psychological injury may require professional treatment, and in making the determination, the fact that the treatment has not been sought is not conclusive. First, we have the issue of the 9-year-old in the car, apparently with special needs, and dad, victim, as expressed in that statement that was just read into the record, how this is still affecting the minor child. And that makes sense in court as it relates to somebody that's 9 years old and was observing somebody pull up next to them and point a handgun at them.
Still haven't been proven for the record.
Mr. Hensley, you've been convicted of that, sir,
Oh,
by the court.
We gonna have our
Okay.
day. We will have our day.
So please let me finish, and then I
Yeah,
certainly
continue.
will give you the opportunity to address the court before sentencing. And then also, pursuant to the statement that was just read into the record from the wife, who also was in the car, according to the testimony at the trial, she is not only suffering from the effects of this, has sought treatment and continues to seek treatment, which is in line with the OV scoring guidelines that professional treatment may be required, in fact has been, and is still being engaged. So we'll score 10 points for OB4. So that will change our total OBs to 35. And does that change the level?
Judge, I changed it to a level 4. And so a C4 cell is going to be 5 to 23. So
All right. Any other additions, corrections, or deletions from the people?
no, nothing from the people, and I know nothing else from the people.
So you've read the statement into the record, then nothing else from victims,
That's correct, Your Honor.
and then anything on behalf of then the people.
Your Honor, the recommendation on the 0 to 17 guideline rate is 12 months on count 1 and 2, and 2 years on count 3 preceding the count 2 sentence. The people did initially support that, but with the change in the sentencing guideline range, obviously this does open up, Your Honor, to more opportunity for incarceration if you so choose, and we would leave that at discretion. But otherwise, we ask that you at least follow the recommendation as intended by Hendricks.
All right. So, Mr. Hensley, I'm going to give you the opportunity before I ask you to address the court for sentencing. Do you have any additions, corrections, or deletions as it relates to the pre-sentence report?
Yeah, I can say.
Do you have any
No accusations.
additions, corrections, or deletions?
All those accusations are false and none of them have been proven.
Okay.
Not one. And he talking with this story.
As it relates to this report, do you have any
don't have no
additions,
report.
corrections, or deletions? Excuse me.
No, I don't have no report.
All right.
Uh-huh.
So, as it relates to sentencing, is there anything that you want to state to the court before a sentence is imposed?
You know, I have my medical information. You know, I have stage 3 cancer. You know, I have head trauma. You know, I have neck and back injury and something with a drop foot. For the record.
Anything else then,
That's
Mr.
it.
All right. So Mr. Hensley has provided, it is accurate, information regarding different medical issues that he has, that he is suffering and is suffering today, as a matter of fact. However, as the court sat through this trial, it's clear to the court that what Mr. Hensley was engaged in is troubling. The testimony of these victims, where they were traveling on westbound I-96, minding their own business, when Mr. Hensley's vehicle comes up behind them, at a high rate of speed. The victim described with great clarity how close Mr. Hensley and his vehicle were to them, to the point they were extremely uncomfortable.
Objection.
Did not, hold on, Mr. Hensley, let the court finish, okay? To the point that they thought they were going to be struck. The victim, I recall, describing being unable to even see the front of Mr. Hensley's vehicle. That's how close it was, meaning the grille, headlights. I recall the testimony. And that they immediately got over. Victim then went on to describe that Mr. Henley pulled up next to them and pointed a handgun in this manner. Of course, pointing over to the right and directly at these individuals. The victim described how he reached back, sort of to shield his family, and that they were getting down as best they could. Now, all of that, I think, is certainly actions that would cause the victims here to feel their life was in danger. Somebody points a gun at them. The fact that somebody is tailgating that closely behind them on the highway at speeds of 70, 75, 80 certainly puts people in danger, could cause people to be incredibly uncomfortable about what's going to happen next. But it's a long way, Mr. Hensley, the court saying, having sat through the trial, you create the situation by driving in a manner that makes these folks uncomfortable, by coming up on them at a high rate of speed and following it now that closely.
Objection, man.
Mr. Hensley.
I drive a
To
BMW.
object to.
Anybody with an autopilot vehicle, you know for a fact it won't do that.
Right.
That's a fact.
So Mr.
Not
Hensley.
what he giving you on out of his mouth. A fact. An automobile will not get up on nobody. Automatically jam brakes. I told you the BMW does that.
The trial is over. You had an
it's not over.
opportunity
It's not
to
over.
cross-examine those witnesses.
I did that, and you deleted everything I said.
Now, court
And
made
you heard
ruling.
everything that they said was a
So
lie.
now
And you know it
need
was
to
a lie.
let the court finish, all right? So the testimony was as the court has described, and there is no doubt that all of those actions Mr. Hensley is responsible for. That's the ironic part of that. He creates the situation that causes discomfort for these drivers, and then he's the individual that introduces a gun to the situation. Court heard 404B evidence that was remarkably similar, where Mr. Hensley is right on the bumper of a young lady, Grand Rapids, Kent County area, and then when she is very uncomfortable and pulls over and stops, Mr. Hensley again introduces a gun, pointing it at that individual.
So this is not his first time doing this?
Now, I mention this because I'm not using that as it relates to a sentencing issue. I'm using that, and that it's clear Mr. Hensley drives in a manner that endangers other people, that causes them to report his activity to other people. And then when they attempt to evade, if you will, what Mr. Hensley has caused, then he introduces a gun to the situation. Now, Mr. Hensley, I don't have to tell you that it's fairly obvious that in today's world, right, today's world of shall issue CPLs, that even if you believe that somehow you're justified in displaying a weapon, and for the record, there's nothing in this trial, nothing this court heard with the 404B evidence or the incident at hand here that we're sentencing you on that would suggest that in any way, shape, or form that you were not responsible, that you had any legal justification to introduce a weapon to it. But even assuming in your own mind that you were, what happens with that in today's world is they would have a very easy avenue to articulate, I felt in fear for my life or great bodily harm, and assuming they were lawfully carrying a gun, could take action, shoot you, in other words. And I can remember just in little Ione County, an incident that occurred just a few blocks from here, in which an individual was tailgating a lawful CPL holder going right down Steel Street over here. And so that individual, much like here, got over, pulled into the car wash to get away from this guy. And the guy behind him pulls right in behind him, much like in the 404B evidence I heard with you. And so what happens is the CPL holder, what is this guy doing? He's crazy, he pulls his gun. Now, you can argue whether he could articulate at that time whether he felt his life was in danger of death or great bodily harm. But regardless, so what happens is the tailgater, he then also was a valid CPL holder, and he pulls his gun. And guess what they did? They shot each other, and they both died. The ironic thing is maybe it's the one time that a government program worked 100%, because to get a valid CPL, you have to take this course, do all those things, and part of that is shooting your gun 15 times or something. I can't remember.
I worked on my own car. I knew about the CPL.
Yeah, well, my point is, so they both hit their mark, and they're dead. And it's started from something just like this. And so my point in demonstrating the story to you, retelling the story, is when you engage in this kind of behavior, it puts your own life at risk. Put your own life at risk. And that you are lucky that hasn't occurred to you, but you certainly have frightened the heck out of people with what I heard in this trial. You certainly were in the wrong, and you're not a valid CPL holder. That's the other problem.
Because I don't need it.
All right, well, I recognize you think that you have some fundamental rights that I'm not aware of found either in state or federal constitution, and you certainly can take those up on review, right?
I'm already in Western District Court already.
So that's fine.
Okay.
You can appeal anything that you'd like, any reason you think you have a valid appeal, but they're simply not found in state or federal constitution. And so here we are today. So that's how we end up with a carrying a concealed weapon, felonious assault, felony firearm. And what the court likes to do, Mr. Hensley, as I'm reviewing this, I will say this, I'm weighing positively in a positive manner here. You stand before the court at age 50, you don't have any prior criminal history.
Exactly.
Which is somewhat remarkable when I heard about the 404B evidence. So
Exactly.
I don't know how that didn't result in some sort of crime, but it didn't. And I'm recognizing that, and I'm going to recognize that in the sentence I'm going to impose here in a minute. We do have the sentencing guideline now, which is 5 to 23 months. Court likes to think about the middle. The middle of 5 to 23 is going to be 14. And I also want to recognize that you don't have any prior criminal history, and that I will also recognize until lately that you've been cooperative with the court. You showed up to court, that you, as far as I could tell, did your very best to represent yourself, and were adamant about doing so and took this matter seriously. All of those things, I think, are things the court can weigh that are positive to you. The negative, though, sir, is the outcome of this is your actions and one causing this and then making it worse with introducing the gun and pointing it at this family on the date in question.
Can they prove that?
They did prove that.
No,
Beyond a reasonable doubt
No,
at
they did
trial.
not.
I recognize you disagree with that.
Because you had
asked the court to
you
decide
had
it,
photos,
and
you
the
had
court
video,
decided it.
you had somebody mouth.
Those are all
Yes.
evidentiary issues that you, again, can explore on appellate review, sir. You're welcome to do that.
Yes.
All right. So as it relates to the carrying a concealed weapon. All right, so carrying the concealed weapon is count or charge number 1. Court's going to impose a sentence of 12 months to 5 years. That's under the minimum guideline range of, or the middle, I should say, of what the court was looking at of 14 months. So it'd be 1 year to 5 years with the Michigan Department of Corrections, and you do have credit now for 14 days that you have previously served. As it relates to the felonious assault, now this would be charge number 2. The court's going to impose a sentence of 1 year with the Michigan Department of Corrections to the statutory max of 4 years. You will receive credit for 14 days that you have previously served. And then as it relates to count 3, this is the felony firearm. The court is required, Mr. Hensley, to impose a sentence of 2 years with the Michigan Department of Corrections. And then counts 1 and 2 that I mentioned earlier will be served concurrently with each other, but this count 3 by statute is required to be served consecutive with and preceding these other 2 counts. So 2 years with the Michigan Department of Corrections. As it relates to the monetary obligations, Mr. Hensley, the court is required by statute to impose $130 as a crime victim rights assessment. Court's going to impose court costs in the amount of $1,500. There'll be a $60 DNA testing fee, and then required by statute are these state costs in the amount of $68 on count 1, $68 on 2, and $68 on 3. All right, so Mr. Hensley, you do have a right, and this is something you're interested in. You've expressed that interest to seek appellate review of the sentence the court has imposed. If you'd like to do that, you have 21 days from today's date to make that request. You have the appellate paperwork there.
Right in front of him along with the pen.
All right.
He's already in the district court. You want the case number?
So hold on. So you have 21 days from today's date to make that request. All right. If you want to ask for a court-appointed attorney as it relates to this appellate review, you have a broader window of 42 days to make that request. Okay. Because you were convicted at trial, you have an automatic right to seek this review, meaning that if you ask for that review, then the appellate court will have to take a look at it. All right. So if you can, then there's a pen there. I need you to sign. There's 2 copies of that. One for you to keep, the other one for you to initial and date that you've received it. So if you could do that for me, sir, it's right there on the podium. This is your all rights.
You can take that with you. I'm not signing anything.
All right. So for the record, Mr. Hensley Bay is indicating you don't want to sign that, sir?
I'm not signing anything.
All right. So for the record, then, though, I am going to send back with the deputy his copy of the appellate review form. I'm going to place the unsigned appellate review form here. Mr. Hensley, only because we've dealt with this case for so long. If you want to explore these, though, this form is important to you, okay? I recognize that you are refusing to sign it or acknowledge it for the record, but this is something that you want to file timely if you want appellate review of this.
They don't have jurisdiction. So if they don't have jurisdiction, neither do you.
All right. Well, I think that the court has jurisdiction,
We don't see
and
it.
if you want this reviewed by a Michigan court, then you need to file that. But I'm going to give that to the deputy. We'll keep it in your possession, and you're free to go.
That's it.
So who do we have at IBC? Are you Mr. Washington?
Yes, sir.
Okay. What are we doing with this today?
All right, you're scheduled for 2 things. One is going to be for arraignment, and 2 is going to be a motion to set bond. As you recall, the defendant is in pro per right now, and he had indicated he was looking to hire an attorney last time he was before your honor. So that's why we haven't considered the arraignment yet. The motion is in regard to setting bond because MDOC is set to release the defendant as he's hit his out date on May 31st of 2024.
All right. So, Mr. Washington, where are you at as far as hiring an attorney?
No luck right now.
I didn't catch that. What?
We can move forward, Your Honor. I'm still searching, but we can move forward.
Okay. Do you want to have somebody from the public defender's office represent you? Do you want to represent yourself? What would you like to do?
I'll represent myself, Your Honor.
Okay. You certainly can do that. I do have to ask you some questions about that, sir. First of all, do you recognize that the charge that you're facing, 2 counts of a 5-year felony, and then as a result of the habitual offender, those could be up to life offenses. So do you understand the seriousness? In other words, the magnitude of the charges, especially when you look at the habitual offender?
Yes, Your Honor.
All right. And then, Mr. Washington, do you understand that if you choose to represent yourself, again, that's something you are entitled to do, but do you understand that you'll be held to the same standards as an attorney or anybody else that's practicing in the courtroom? Do you understand that?
Yes, sir.
All right. And as a result of that, if you do not have the training or experience or the education, you could be at a disadvantage. Do you understand that?
Yes, sir.
All right. that's a long way of saying that the state is generally represented by attorneys. And I don't believe, but I don't want to offend you, so let me inquire, are you an attorney by any chance?
No, sir, I'm not.
All right. What's the highest grade that you've completed?
7th grade, sir?
7th?
Yes, sir.
All right. So that's why we asked. So do you recognize then you certainly will be at a disadvantage if you're attempting to do this on your own versus the people that are represented by an attorney?
Yes, sir.
Okay. And knowing all that, you still wish to represent yourself?
Yes, sir.
Okay. And Mr. Washington, if that changes at any time, you certainly can let the court know. And first, you could always hire an attorney. And second, you can always then ask for court-appointed attorney, and then you can go through that process to be screened. Do you understand that?
Yes, sir.
Okay. So let's start with the arraignment. And count 1 of this information, you're charged with assault of a prison employee. That's a 5-year felony and or a $2,500 fine. And then in count 2, you're charged with the same crime, assault of a prison employee. Again, 5-year felony and or a $2,500 fine. Mr. Washington, do you understand the nature of those 2 charges?
Yes, sir.
All right. Do you understand the maximum penalty for both is up to 5 years?
Yes, sir.
All right. And then as I mentioned earlier, there's also this habitual offender notice here. And that is a habitual offender 4. And that means that the penalties that I read to you are life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years, and then the maximum penalty cannot be less than the maximum term for a first conviction. So that means that those 2 charges I read to you earlier can be up to life. Do you understand that?
Yes, sir.
All right. So knowing all that, sir, I'm going to enter a not guilty plea to those charges on your behalf. And then we'll schedule this on for our next proceeding, probably like I don't know, I guess we could do a status conference in maybe 3 weeks or something like that, 2 or 4 weeks. Again, you're always free to hire an attorney or request court-appointed attorney. So then we also have to then take up this bond issue, and Mr. Butler.
Yes, thank you, Your Honor. We received information from MDOC that the defendant is going to be released from the Department of Corrections on May 31st of 2024. We did confirm that at the defendant's arraignment in district court here on the case at hand, that a bond was not set because the defendant was inmate with MDOC. We are asking that the court set bond under MCR 6.106. Some of the factors for Your Honor to consider is the defendant has a very lengthy criminal history dating back to 2013 with attempted larceny of a building. We have attempted assault with a dangerous weapon. We have felony larceny from a person, assault and battery. In 2014, we have MDOP less than 200. In 2016, assault and battery. 2015, another MDOP between 200 and 1,000. 2016, we have a conviction for domestic violence. And then in 2016, we have attempted flee and elude 3rd degree. 2021, we have domestic violence and attempted resisting and obstructing the police. 2021, operating while intoxicated. Again, that same year, use of methamphetamine and another operating while intoxicated. And then lastly, we have felony firearm in 2021. In this case, I don't believe the defendant has any ties to Ionia County that I'm aware of. In this case, he assaulted a correction officer. There's 2 charges of that. The likelihood of conviction is high. He scores 19 to 76 with the habitual 4th offense. Preliminary examination did run in this case. And then just to push it over the top, we just received a warrant request yesterday for the defendant for another assault of corrections staff, and we just authorized that as well. And it's what happened a couple of weeks ago. So we would ask for a significant bond in order to not only protect the community, but also to ensure the defendant's appearance at future court dates.
Okay, Mr. Washington, what's your position on bonds, sir?
Yana, I'm not able to post bond.
All right. So the purpose of bond is twofold. First, it's to ensure the appearance of the defendant, and second, it's to protect the community. As it relates to this first prong, does not appear that Mr. Washington does have any ties to the community. Also, he is facing significant guidelines with a 19 to 76 range. And then as I just read into the record, this habitual offender fourth, which means that the penalty, the maximum penalty, can be established by the court, but it could be up to life. Also, it sounds like he also has a new charge, meaning that allegedly he has violated the, we don't have a bond set, so he hasn't violated the conditions of bond yet, but he has demonstrated, as we're talking about, the protection of the community. In this case, the community found within the Department of Corrections, another alleged assaultive crime, in addition to the two that he's facing here. He does appear to have a significant criminal history, which is a factor for the court to consider in setting bond. In particular, I think that relates to the idea of protection of the community. That criminal history involves numerous assaultive crimes, at least one firearm conviction, and then new allegations here of assaultive crimes that have been charged and one that was recently charged. All of that would suggest that a bond is appropriate. I'm going to set bond at $150,000 cash or surety. Mr. Washington, if you are able to bond out, you still need to be present for our next court date. I'll go ahead and I'll schedule this now. Why don't we put that on? Today is the 14th. Why don't we just go out to the 11th of June for a status conference? No docket day then. Okay, so we can go the 25th. 25th of June for a status conference. And then two things we can hopefully accomplish by then. The new case should have already been in district court. We can see what's going on with that. And then maybe there's something that you could work out to resolve all of these. I don't know. And then certainly, Mr. Washington, you're free to hire an attorney in that time frame here. You've got a few weeks, and or then make a request to have the public defender's office screen you for representation if you'd like to do that. And of course, you're always free to continue to represent yourself also, okay?
Sir.
So that'll conclude the matter today, Mr. Washington. If you've got an officer there with you, you are free to sign off. We're gonna sign off on our end, and then I'll see you back here on the 25th of June, okay?
Yes, sir.
All right, thank you.
The court may.
Maurice Wallace.
Yes.
All right, now calling the matter of the people versus Maurice O'Neill Wallace. This is ticket number SP 1461720, count 1, drive unregistered untitled motor vehicle, count 2, no insurance misdemeanor. Ticket number SP 1465917, count, no proof of insurance. Ticket SP 1465916, drive unregistered untitled motor vehicle. And ticket number V 1231971, count, fail owner's duty of care. Appearances for the record, starting with counsel, please.
Good morning, Harry, for the defendant. State your name, sir.
Maurice Wallace.
We're here for an arraignment, so he waives any formal reading of the information or complaint or warrant, stands mute for that purpose, and asks for a trial date by Zoom, please, a waiver trial.
All right, if that's the case, please Hold on.
It's the nature of the charges against the defendant here.
I figured as much. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, or nothing but the truth? Mr. Wallace?
Yes.
All right, you can put your hand down. Did you have a chance to talk to an attorney about your case and about your rights? Mr. Wallace?
Yes.
Okay,
I
can
just
you
been
hear
on
me?
the phone. Yeah, I can hear
Can
you.
you-
I can hear you.
Okay. Okay, I know you're on the phone, but for this, I'm gonna be I have to see you. So do you need to physically come in person?
I mean, I can come in person or, I can go on Zoom. I mean, either
Right,
or.
but I have to physically be able to see you on Zoom. You're on Zoom right now, but you're on the phone, so I can't physically see you. Are you going to, so my question to you again, listen carefully, is are you gonna be able to get on Zoom, or do you need to physically come in person so that you can be in the courtroom?
Okay, I need to get on Zoom now.
No. All right, for the trial, and I
When I
apologize,
come-
I wasn't clear about it for the trial purposes.
Okay, well, I'll be able to get on Zoom.
For the
I
trial?
I got Zoom on my phone. Yes, I have
Okay.
Zoom on my phone.
Okay, I'm just checking because that's gonna determine the date that I do it on, okay? I just was trying to figure out, okay?
Okay.
Okay, I'm
Your
gonna do
Honor,
it
if I
on
may-
May. Yes,
May I interject, Diachiku Mason, City of Detroit, 43471, just in case there is an animal cruelty. Is he the same person with the V ticket?
yes,
So
yes.
there might be discovery he needs. Do you want to appoint so that we can give discovery on animal
Probably
cruelty?
so. Yeah.
Well,
All
it's
right.
okay because I already had my tenants had already taken care of that.
Okay, so Mr. Wallace, you don't know this, but sometimes we have issues with different cases and then there'll be discovery and they'll want to talk to you about it. Now you can move forward just to have a trial in this matter, but also know that on the day of trial, I don't like to adjourn them because now you want to have discovery and go over and discuss things. Without an appointed counsel, you won't be able to discuss anything until the actual day of trial. Are you going to be comfortable with that and want to move forward?
No, I'm not. I'm not comfortable with it because I just own the property that my tenants
Okay.
is on.
All
I'm
right,
trying
so
to
here's
figure
what I'm
out-
going to do, Mr. Wallace. I'm going to have you appointed some counsel. So I'm going to have you come back on April the 2nd for a pretrial, but I need you to call the courtroom so we can get some information from you so I can get counsel appointed. So that way they can talk to you and you can get all this hashed out before we have a trial. Because on the day of trial, I don't want us to have to adjourn it because now you want to have a discussion about it, okay? And then they can talk to you and share all the law and all the rules so you're very clear on it.
But I had went to court on it already in front of you.
No, you failed to appear on December the 8th on this ticket.
I said I appear when I'm in jail in West Virginia.
I said you failed to appear.
But I was in jail in West Virginia.
Okay, so did you come when you were in jail in West Virginia?
No, I never knew I even had no ticket
Okay,
or no
so
case.
Mr. Wallace, listen to me. I said failed. Maybe I shouldn't have said failed. You didn't show up to the court dates that we put out there. That's why you had this court date today. And it sounds like you didn't show up to them because you were you weren't able to. So that's all I'm saying. Failed to means you didn't show up to these court dates. And it sounds like you had a reason or what a method of why you didn't. That's fine. I don't care. You're here now. All I'm asking is that we want to appoint some counsel so that on the day of trial, this doesn't turn into we need to adjourn this to another date because now you have lots of questions about what took place and what happened.
Mhm.
Or it's up to you. You don't have to have appointed counsel. I'm not going to adjourn this case though we come the day of trial and now you want some extra time. I can tell you that much.
Oh no, I mean I don't need no extra time for nothing because I already know what I did and what I didn't do.
Okay. All right. All right. So I'm going to set this matter for a bench trial on May 29th. I will not adjourn this case. We will move forward that day, May 29th at 9:30 a.m. I'll set this and your bond at $0 personal. I'm gonna make a note to myself to look back at the YouTube video so I can remember our conversation that we have. All right, I gotta see you physically that day somehow. So whether it be by Zoom or in person, I have to see you for the trial, okay? All All right, you're all set, Mr. Wallace.
Okay, thank you.
No problem.
Yeah, could you release Corporal McCree, because he never checked in either. He was from
Corporal McCree, you're all set. The person never checked in. Mr. Wallace didn't check in today, so you can go ahead and keeping our city together, please, and thank you.
Thank you so much. Have a good day.
You too. Thank you.
Shocking. He didn't show for his bench trial. Oh, I'm so surprised. Who didn't see that coming?
All right. I bring in Miss Morgan. She is doing a lot of walking. I had to take her out for a second. Miss Willis Morgan.
I'm here, Your Honor.
Okay, I got to see you the whole time, so you're gonna have to put your face in the camera for me, okay?
I'm sorry, my phone was dying. I had to run into the store to get
Oh, and you breaking up. Oh, and you're breaking up.
Can you hear me?
I can hear you now. Now calling the matter of the people versus Felicia Willis Morgan. This is case number SP 10220701. She's not on the docket for today, Attorney Mason. Counts 1 is license improper. Count 2, unregistered motor vehicle. Count 3 of that same ticket is improper plates. Ticket number SP 1523653. Count 1, expired plates. Count 2, no valid registration certificate. Count 3, no proof of insurance. Ticket number SP 8535621, no operator's license on person. Ticket SX 3596171, no operator's license on person. And ticket number 172638281, no operator's license on person. Appearances for the record, starting with counsel, please.
Hi, Harry Baughman, the defendant. State your name, please.
Ma'am, no, all right, I'll put her in the waiting room. I'm gonna wait till she finished getting out that store. I can't do it. Don't worry, we're gonna skip over her. She's taking care of business. That's fine. She's just gonna have to wait a minute. All right. Miss Willis Morgan, you finishing the store now?
Yes,
Okay.
ma'am.
Recalling the matter of the people versus Felicia Willis Morgan. This is ticket. I caught these tickets entirely. We just paused the hearing for a moment so that I could be able to allow her to finish what she was doing so she could pay attention to this court hearing. Appearances for the record, starting with counsel, please. Attorney Boffman. Attorney Boffman. All right, ma'am, you need a pretrial so you can come back to take care of these.
Yes, I'm guessing. I'm not.
Are you in
Yeah,
compliance with any of this stuff? Or are you close to becoming in compliance with these things?
No, I'm not. No, I'm not. I had some financial difficulties.
Mm.
I had
Okay.
some financial difficulties, but I'm trying to pay whatever I can. He did let me know that I could go to the Secretary of State and pay for my reinstatement. I didn't know that. So that's where I actually was at when you clicked me back in. I was grabbing a charger. I walked.
I figured as much. I just knew you were talking to somebody, so I didn't want me to ask you questions. You got two people asking you questions. And so I paused for a moment. It was just to give you some time so that you could take care of what you needed to take care of. So this is why I'm asking Mr. Morgan, Willis Morgan. I'm trying to figure out how much time you need additionally. Like, do you want me to give you some time, or are you going to come back and try and resolve it? What do you need me to do?
If I had to pay, what would be the amount of payment?
I mean, right now you got a ton of tickets in disposition. No, I lied. You got most of your tickets are closed. It's just these warrant tickets. So I'm gonna look at some of these tickets that are in disposition and I'm gonna put them on my docket because they're not too old, my clerk said. And then you do have some reinstatement fees that you need to pay through the court. It looks like 1, 2, 3, 4, 5 of those. They're $45 a piece. And probably another one with this no proof of insurance, because that's probably one of the ones that's stopping you right now. So we
Judge,
just
you want to
got.
resolve this matter right now? I mean, from what you gave me, you want me to make an offer right now? We can try to.
Does she want to try and resolve it? I don't know.
We can.
Okay.
Whatever is easier.
Well,
Okay.
we want to do what's fair for you, not what's easy.
Yeah.
It's gotta be-
Right.
She's
So
got
she
three-
has some. She has
got-
3. She got 1, 2, 3. 3 no operators license.
Yep.
License improper.
Yep.
Unregistered motor vehicle.
Improper
And then she-
plates.
Proper plates, expired plates, no valid registration. I know that's not on there, and no proof of insurance. They're all from last year though.
Those still in just as the default. You want me to set aside the default on
Yep.
those?
Yeah,
Set
can we
aside-
please and help her out?
Yeah, let's set aside the default. Dismiss those.
Okay.
I'll give her an allowing. Let's drop those NOPs. I'll give her an allowing,
Okay.
and I'll get an improper plate. How's that?
That's
Oh,
nice. Thank
that's
you.
That's fantastic. You want
It
to take
is
that offer
nice.
today, ma'am?
Yes, I appreciate it. I really do.
We know, we see you trying to hustle and get it together, okay? All right. Give me 1 second. Can I just come back to your case 1 second? You've been so patient, miss. I promise I'm gonna help you out. I want to get Miss Ward out of here. Miss Ward, 'cause I don't know what she's doing. All right, Miss Ward.
Hello,
can you
hi,
unmute?
yes.
You gotta put your camera all the way down so I can see your face, even if you're eating right now. Okay.
Okay.
All right. Now calling the matter of people versus
Oh,
Latricia Renee Ward. This
Mhm.
is ticket number SP 483881. This is count 2, improper plates. Count 3, drive unregistered untitled motor vehicle. We have ticket number SP
Yes, Your Honor.
121037.
You guys back on the record?
Oh, hold on. Sorry, I got it. Ticket SP 1210376. 1 count drove while license suspended. Ticket SP 1365550. Count 1, smoking marijuana within passenger area of a motor vehicle upon public highway. Count 2, open alcohol motor vehicle. And we have ticket number SX 243142. Count 2, no operator's license on person. May I have your appearance for the record, counsel, starting?
Harry Boston on behalf of the defendant.
Ma'am, can you state your name for the record?
Latricia Ward.
All right.
Matters are set for trial this morning. There's no complaining witness in any of the enumerated cases. Would you consider a motion to dismiss here without prejudice?
I will, and I looked to see if any of those officers came. None of them came, so the court is going to grant your request. I'm going to
Your Honor,
dismiss
didn't we
these
get
matters.
the Oh, I was gonna say Majid Hussein called in, I believe, according to the court officer.
Did I get that sheet? Did he come in?
I think she told me that he was sick. He called into the court, and
Okay.
I'm sorry about that though. So I
Okay,
don't
I
want
don't have the sheet. Yeah.
Okay, I don't want to give him a no PO. That's all.
Okay. All right. Okay. No, he didn't. It's okay. All right. So that's just the drove while license suspended ticket. The officer is sick on that today, Miss Ward. I can dismiss all the other tickets for no officer. How do you want me to move forward on this ticket where he's sick?
Ma'am, do you have currently a valid license?
No, I can't get my license until August 13th.
Okay.
Judge, I'll give her an allowing.
Thank you.
Okay.
That
Would you
won't
like an
go on your
allowance?
record, ma'am. You pay a fine for that.
I'm sorry, I couldn't hear you.
If you're willing to plead guilty to allowing an unlicensed driver to drive, we'll resolve that driving while license suspended case this morning. You
And
pay a
how
fine.
much is the fine?
It's up to me, the judge, and typically I do $200.
Okay,
Is that something you're
fine.
able to afford?
Yeah, I can afford it.
Okay, and I'll give you some time if you need additional time to pay it. You understand?
Okay, how do I pay it while I'm on here or?
You can go online to 36districtcourt.org, or you can physically come down to the courthouse to take care of it. But I had to
What will I
swear you
put
in
in
first.
when I just put in my
I'll give you the
name?
information. Yeah.
Okay.
All right, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Did you have a chance to talk to an attorney about your case and about your rights?
Yes.
Did anyone threaten you, force you, or promise you anything in exchange for a plea today?
No.
Are you pleading guilty of your own free will?
Yes.
Are you pleading guilty because you are guilty?
Yes.
And do you understand that by taking this guilty plea, that you're going to give up the rights that you had to have a bench or jury trial in these matters? You understand that?
Yes.
Understanding all of this, did you still want to move forward today?
Yes, I do.
All right, I want to take your attention back to the date of June 13th of 2021. At that time, were you in the area of Dexter and West Davidson in the city of Detroit driving a Dodge vehicle?
Yes, I was.
And while you were driving that Dodge vehicle, was your license suspended at the time?
Yes.
Satisfied, counsel?
Satisfied. Thank you, Your Honor.
All right, of course, satisfied as well, and will accept the plea to the reduced charge of allowing unlicensed driver to drive. Now, this shouldn't affect your time to get your license back, okay? Because it won't abstract, and so you won't get caught and dinged for it. But you do have to pay the fine, $200. I'll give you 60 days to pay that. You can physically come down to 36th District Court. Just give them your ID. They can look you up in the computer system, or I can give you the ticket number too, and they can look it up that way as well, okay?
Okay. Can you give me that ticket number?
I sure can. You ready?
Okay. Yes.
SP 12 10 376. Count one.
You said SP like superpower 1210.
Superpower. Yep, superpower 12
376.
1. Do one at the end too.
Okay. 3761.
Yep.
Okay. Thank you.
Okay. You're welcome, and I'll give you 60 days to pay this, but pay this so that way it's not even blocking you from doing anything you need to do, okay?
Okay, thank you.
So that's May 1st. Thank you so much. You've been patient and kind today, Ms. Ward.
Well, thank you guys. Have a nice day.
All right, have a good, you too. Thank you for that catch too. I appreciate it. All right, I'm just trying to get a ROA. Let me get this ROA printed out for her. She's gonna take a plea. Recalling the matter of the people versus Felicia Willis Morgan. Appearances for the record, starting with counsel, please.
Often for the defendant, state your name.
State your name for us, please.
Felicia Willis Morgan.
Thank you.
You're welcome.
All right, counsel. We've reached a resolution in this. Is that correct?
I'm sorry, forgive me. There's a plea deal. The defendant's going to waive her rights. She's pleading guilty to allowing an unlicensed driver to drive and to improper plate.
All right, if that's the case, ma'am, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you can put your hand down. Did you have a chance to talk to an attorney about your case and about your rights?
Yes, I did.
Did anyone threaten you, force you, or promise you anything in exchange for this plea today?
No, they didn't.
Are you pleading guilty of your own free will?
Yes, I am.
Are you pleading guilty because you are guilty?
Yes, I am.
And do you understand that by taking this guilty plea, that you're going to give up the rights that you had to have a bench or a jury trial in these matters? You understand that?
Yes, I do.
Understanding all of this, did you still want to move forward today?
Yes, I do.
All right, I want to take your attention back to the date of, looks like September the 2nd of 2019. Were you driving a Chrysler vehicle in the area of Schoolcraft and Schaefer in the city of Detroit?
Yes, I was.
While you were driving this vehicle, was your license not valid at the time?
No, it wasn't.
Was it also improper plates on that vehicle at that time?
No, it wasn't.
There was it, or was it not proper plates?
It was not.
Okay, all right, satisfied, counsel?
Satisfied. Thank you, Your Honor.
All right, stipulation for probable cause on the remaining counts to be dismissed. It says so stipulated. All right, so at this time, the court's gonna enter a plea to the amended charge of allowing an unlicensed driver to drive and one count of improper plates. Ma'am, you have 1, 2, 3, 4, probably 5, 6, 7 reinstatement fees. Okay, they're at $45 a piece. You may have one more too. You need to pay those, okay, so that you can get your license back. All right, driver to drive. All right, that's my fine today. You got to pay all those, okay?
Yes, ma'am.
All right. And then we'll take care of all these tickets. Make sure you take care of this so you can try and get your license back, okay?
Do I pay it to you all or do I pay it at the Secretary of State?
So you come down to 36th District Court. What ends up happening is when you pay it here and take care of it, it'll send clearance over to Secretary of State's office. They have additional fees that you have to pay separate from ours. But pay our fees and fines. It's probably gonna be close to $300, almost $400, because that's how many you have. Take care of them so that way you can get the clearance so that you can be able to go to the Secretary of State's office and take care of it, okay?
Okay.
Okay, thank you. You've been patient for these couple of days. I remember you from Monday holding tight. I appreciate it. So that's why I'm trying to get you what you can get, okay?
Thank you so much. I'm about to give me an Uber and come down now.
Oh, wow. Okay, let me get these to my clerk so we can put them in, okay?
Yep, absolutely. I
right,
appreciate everyone. Thank you.
Oh, no problem. All right, if there's nothing further, you're all set, okay?
Okay, you guys have a good one.
You too.
Bye-bye.
Bye-bye. All right, Rodney White. That's the date you gave me for him. All right.
Yes.
Whew. All right, I'm gonna just call his tickets and not necessarily all the tickets specifically. Now calling the matters of the people versus Rodney Kawan White. This is ticket SP 1073146, counts 1, 2, and 3. Ticket number SP 1085328, counts 1 and 3. Ticket SP 1157621, counts 1 and 2. Ticket 416006, counts 1, 2, and 3. Ticket SP 1232348, counts 1, 2, and 3. Ticket SP 1259521, counts 1, 2, and 3. Ticket SP 1259523, count 1. Ticket SP 1280688, counts 1, 2, and 3. Ticket SP 128066961, count 1. Ticket SP 1291047, count 1 and count 3. Ticket SP 1298157, count 1. Ticket SP 1298167, count 1. Ticket SP 1346377, count 1 and 2. Ticket SP 1422506, counts 1. You can't see it, Mr. Boffin, but he adjusting himself, zipping up his coat. He done set his stuff down. He fixing all kinds of stuff up. These his cases.
Mr. White.
Stop moving. What are y'all doing? Like, for real. I just want to invite everybody back to court from now on. Because when you at home, you just feel like you're doing whatever. I let you do whatever you wanted to do for the last few hours. I know you've been waiting. So for these few moments, you just need to be still. That's it. Just be still, everybody. Just be still for a few moments. Ticket SP 1422506, counts 1, 2, and 3. Ticket SP 1435892, counts 1 and 2. Ticket SP 1435977, counts 1 and 2. Ticket SX 4131560, counts 1 and 2. Appearances for the record, starting with counsel.
Good morning, Harry Boffin. For the defendant, Mr. White, state your name, please.
Rodney White.
So the defendant's been advised of his rights. At this time, he will waive any more formal reading of the information complaint or warrant, stand mute, and ask for a pretrial date to return.
All right, at this time, the court's going to enter a plea of not guilty on your client's behalf. I set these matters for a pretrial on the date of March 21st. March 21st. It's going to be at 8:30 a.m. I'll set his bond at $0 personal unless he's paid some money. That money will remain as a bond hold. If he hasn't paid any money, everything will be $0 personal. All right, I'll see you back March 21st.
All right, see you then.
Like nobody could behave tonight. All right, guys. I had more, but I think we'll run that tomorrow because I'm snuffly and I'm tired and I'm sore and I want to take my meds and go to bed. I'm sorry, I'm selfish. I know. Thank you guys so much for coming and hanging out with me, though. I had so much fun tonight. You guys are the absolute best. I'm gonna try. Yes. I love you. And remember, pics or it didn't happen. Thank you guys so much. I love you all. Be safe, be well, sleep sweet, and much love. It didn't take. I hit the end button and it didn't take. I just usually have to stare at the screen until it says, how did it go? And it didn't give me the how did it go. I'm going to try this again. Oh, you okay, baby? Oh, just in time, because Ava's got to go potty. Be safe, be well, sleep sweet, and much love.